inspire us in South Africa, and also what it means for us today. So I thought I'd start by taking us back to the United States in the 1960s, where the women's movement is beginning to gain momentum, beginning to think about going to court to litigate. The second wave of women's struggles is focusing particularly on the personal, and therefore people are going to court on things like contraception and abortion. In the 1960s, the states in America are uneven, but a lot of them are actually, let alone stopping people getting abortions, they're not even allowing married couples to access contraception. So the start really of what is a long line of cases which ends in gay marriage in the States is the 1965 case of Griswold versus Connecticut. And that's a case that challenges the prohibition on contraception to married couples. And in that case, the Supreme Court finds in the 14th Amendment of the American Constitution, which is their due process liberty clause, also the equal protection clause, but finds in the right to liberty and due process a right to privacy on family decision-making, on decisions around your family and your intimate relations and your reproductive autonomy. That's 1965. 8 years later, it's 8 years later that Roe versus Wade happens. And in that case, the restrictive abortion laws in Texas are challenged. And that's the famous case that we all know, right, where the Supreme Court, I think on about 7-2, I think it was at that stage, finds a constitutional right to abortion for women in the United States Constitution by interpreting the right to liberty in the due process clause, building on Griswold versus Connecticut, which is a really important precursor to this, to say that the right to privacy includes the right of women to decide to have an abortion, which is, and they put in place the trimester approach, right, which you'll be familiar with. The first trimester, women's rights are almost unrestricted. The second trimester, you can regulate them for women's health. The third trimester, you can regulate in the interests of protecting potential life. So that stands for 20 years. The next big challenge, but it's controversial all the time, right? And what happens in America is because the right is constitutionalized, it becomes very litigious because, of course, the anti-choice movement is constantly putting in place laws that challenge the barriers, and women's rights organizations are having to go to court to challenge state laws which overstep the mark. So it ends up in court a lot of times, but the second important case is the case of Planned Parenthood versus Cathi, which is very similar to Dobbs versus Jackson because it's also a challenge to Roe versus Wade, and it also talks about the stare decisis principle. But in Planned Parenthood versus Cathi, in a very split judgment, the court nevertheless, more or less, I think it's 6-2 or 7-3 in the end, affirms the essential holding of Roe versus Wade, which is that women have a right to terminate, but they change the basis and they talk about women have a right to terminate pregnancies up until around viability, which is thought to be 23, 24 weeks, but that states can regulate before and after viability in the interest of women's health or fetal potential life. As long as it doesn't place an undue burden or an obstacle in the path of women seeking abortions. They go through the principle of stare decisis in great detail in exactly the same way as happened in Dobbs with the opposite conclusion. And they say that it's not wrong in law. And in fact, there's absolutely no reason to overturn Roe versus Wade. So that's 30 years later. No, that's 20 years later. 30 years after that, of course, is the Dobbs case. So 50 years, as we know, after Roe versus Wade, and many, many, many cases before the state courts and the US Supreme Courts. Of course, you know, with packing of the Supreme Court, we now suddenly find that these two really hard fought over precedents of Roe versus Cathi are egregiously wrong, right? That there is no explicit right to abortion in the American Constitution, and it cannot be implied, as it was not part of the idea of the Founding Fathers in 1868 when the 14th Amendment was brought into being. So really resuscitating a not very well liked sort of original intent doctrine of the US Supreme Court, to basically say that because the men that were in power then, yeah, you know, you've seen it in the press, you know, didn't think about abortion, there can't be a right today. So we know that's left the US in complete disarray. So the question is, what about the rest of us, right? And I'm going to talk about South Africa. I want to start by saying that Roe was very inspirational for those of us who engaged in abortion law advocacy and reform in the 1990s. And it inspired us, but it inspired us both positively and negatively. We knew the American situation well. We were told it by American scholars. We'd read it up ourselves. And we didn't want to be in the American situation, which was where the right to abortion was consistently litigated over the meaning of abortion rights. And women's organizations were consistently forced into defensive posturing because they were always having to go to court to challenge these state laws emanating from Texas and Missouri and Mississippi and all those red states that were really trying to push back women's rights to abortion. So we knew in the 1990s that we needed two things. We needed a clear constitutional basis for abortion, which wasn't the case I mean, you can argue it was the case in America, but of course it was interpreted. And we needed good national legislation, which of course the Americans didn't have either. So we aimed for both and we got both. In 1996, when the Constitution was being written, so abortion was never going to be an issue in the first Constitution. The ANC was not in the majority. It wasn't something we wanted to fight the National Party, et cetera, et cetera. So we'd held it over for the 1996 Constitution. I still have the memo that I sent Frene Ginwala, where I was saying to her, what we need is we need multiple rights, and we need a right to reproductive decision-making as well. And that's what we got, right? So in our South African Constitution, as you well know, reproductive rights are a package of rights, but we have a very clear right to bodily and psychological integrity and to reproductive decision-making. So unlike America, South Africa has a clear constitutional right. Secondly, of course, we have the Choice on Termination of Pregnancy Act. Even in that act, we were inspired by Roe versus Wade, because for those of you who know that act, you'll know that the act is more or less based on a trimester system. So it's kind of derived from the Roe versus idea, whereas in the first trimester, you can access abortion more or less on request. In the second trimester, you can do so subject to certain conditions, and there's certain sort of medical conditions around which healthcare workers can do it, and that you have to go to a designated facility, etc. So in the interest of women's health, that second trimester is regulated. And in the third trimester in South Africa, it's incredibly difficult to get an abortion in the interest of fetal life, and only in very narrow circumstances can you get one. So to some extent, we were inspired by Roe, and sort of in relation to setting up the law. So in South Africa, I think we were ahead of important developments in Africa. Our law was in place by 1996. The Constitution was in place by 1996, well before the Women's Protocol. And indeed, the early years of implementation were very positive years. They were rollout years. Maternal mortality went down, safe and legal abortions went up. But the anti-choice movements didn't stop, right? And before Roe versus Wade was overturned, the kind of American right wing was in South Africa, feeding the South African anti-choice organizations and movements and ideas. And we were consistently having to defend the Choice on Termination of Pregnancy Act in court and in Parliament, right? So in court, there was an initial kind of absolutist ideological challenge saying that our Constitution protects the right to life of a fetus, and the Choice on Termination of Pregnancy Act is unconstitutional. That was kicked out on an exception. because we had such powerful constitutional rights in the 1996 Constitution. Similarly, with the second attack on the legislation, which was an attack on minority consent. Both of those were very successfully defended at a very early stage of the attack in courts. So I think even today, we're very safe, and I say this with fingers crossed, but I do believe this. I think we're very safe in terms of having an intact law that will be defended in court. So that's, I think, the first point. I don't think we're in the Roe versus Wade situation. We're very different. Secondly, though, what about Parliament? So, because of course, can Parliament now amend this law? Because of course, Parliament has that power. So there certainly have been attempts in Parliament to amend the law. In fact, the law amendments to the Abortion Act were in the Doctors for Life case and were sent back for procedural consultation. That was sort of less important. But there were two private members' bills in Parliament. I don't know if you remember. There was one in 2007, both from the ACDP. There was one in 2007 where Dudley introduced a 17th constitutional amendment on the right to life of a fetus, which didn't go very far at all. And there was a second one in 2017 where the same member of Parliament introduced a private member's bill on bringing in amendments to the Choice on Termination of Pregnancy Act, where she tried to put in place ultrasounds and pictures of fetuses and waiting periods and all kinds of procedures that they had used in America to try and dilute women's abortion rights. That didn't get anywhere either. So up until this point in time in South Africa, we have an incredibly sound constitution and legislative framework that has really defended women's rights in theory. And I think it will continue to do so. I think the problem for us, and I'm going to end here in a few minutes, is not legal, but political. So it's not a question of courts and law. I think it's a question of politics and implementation. So we all know that in South Africa, we already have weakening implementation. Implementation of the law is far worse now than it was in the first 5 years after the law started. Maternal mortality has gone up again. So women are dying again of septic abortions. Designated facilities, I think, are down to 7% of health facilities and hospitals. So only 7% of our health facilities actually take on abortions, accept women to assist them with abortions. And even fewer in rural areas. So we know that some of that is just a bad health system, without question. Can't blame it on anything else. But some of it is really that we face hostile and negative attitudes. Women who are seeking abortions in public hospitals can face hostile attitudes from security guards and cleaners through to nurses and midwives and attending staff and doctors. They can have to arrive at 4 in the morning. They're made to queue outside in the freezing cold. They really are treated very badly. So a case like Roe versus Wade really gives power to those kinds of views, right? It kind of empowers and gives muscle to the anti-choice movements. So it's dangerous for us in the sense that it makes it more difficult for us to deal with conscientious objection, with hostile views, with stigmatizing, with reluctant public health officials. So in that sense, I think it's definitely going to feed into South Africa. I also think that there's possibly more funding now available to the right, more funding. Some of you might have bumped into things called pregnancy crisis centers, which are not at all facilities offering help with assistance with terminating pregnancies. They're there to persuade you not to terminate your pregnancies. And those have sprung up even on university campuses. So to me, the kind of political balance of forces in terms of the power of the anti-choice movement to stop women legitimately securing safe and legal abortions in South Africa is where the problem lies for us. And I think I'm going to stop there. I know time is running on, and we can pick up more in discussion, Ropa. Thank you.
Thank you so much, Prof. Albertyn, for that insightful discussion. I'm not sure if Prof. David mentioned, because I dropped out for a second there, but our last speaker is not going to be able to join us today. So to all speakers, if you'd like a few more minutes to conclude, that's perfectly okay. And I think we'll also have a lengthy discussion afterwards as well. And so I'm going to introduce our second panelist now, and that is Dr. Satang Nabaneh, who is a legal scholar and human rights practitioner from the Gambia. Her expertise spans international human rights law, human rights in Africa, gender equality and women's rights, as well as democratization in Africa and comparative constitutionalism. She's currently the Director of Programs and Research Professor at the University of Dayton Human Rights Center in the United States, and she's also a postdoctoral fellow at the University of Pretoria. Most recently, she was managing the Sexual and Reproductive Rights in Africa academic program at the Center for Human Rights, which is also at the University of Pretoria. Dr. Satang, over to you.
Thank you very much, Roper, and thank you for the invitation to join this very timely discussion. My greetings to Professor Cathi. It's always difficult to come after her, given that she is one of the giants and the gurus that we stand on, and she has been amazingly helpful, especially in terms of accessing her archive. I did my doctoral research on consensus objection in South Africa, and I can say that the amount of materials that Cathi has should be in a museum somewhere. Anyway, yeah, and so in terms of the discussion itself, I think just taking from where Cathi stopped, especially in relation to the likely implications of Dobbs. I think for me, in terms of my intervention, given that I do work, especially in supporting the African human rights system in relation to the rights of women, I thought perhaps giving a perspective from the African regional perspective would be great. I was hoping that Joshua will be here, given that we had a recent case from Kenya, which will be exciting to talk about. So hopefully we also do have folks in the audience as well that can reflect on that. In relation to the African human rights system, we know that the African human rights system at the regional level, we do have amazing human rights instruments, including the African Charter on Human and People's Rights, as well as other human rights instruments. However, given the need for a specific women's rights convention in 2003, the protocol to the African Charter on Human and People's Rights was adopted and came into force, which is called the Maputo Protocol. The Maputo Protocol is one of, can I say, one of the most progressive international human rights instruments, given that it has very progressive provisions, especially around female genital mutilation, and other women rights related rights or issues. However, specifically, the Maputo Protocol provides for the right to abortion, which is the first human rights instrument that actually enshrines a right to abortion. It has currently been ratified at least by 42 African countries, which is a great ratification number. And really, just in terms of Article 14 and the reasoning behind it is, one is in relation to the backdrop, in relation to our colonially inherited abortion laws that we have in quite a number of African countries. As Cathi highlighted, especially with the Choice and Termination of Pregnancy Act and the South African trajectory, it is quite different from mostly the rest of Africa, which has and continue to have inherently colonially inherited abortion laws that are very much premised around the crime and punishment model. Also because of the crime and punishment model and making abortion illegal or criminalized in a lot of cases in quite a number of the African countries, that this has led to Africa having an undue burden in relation to unsafe abortion and mortality and mobility related to unsafe abortion. And so as a result, the Article 14 really comes in as sort of a solution in relation to addressing that particular problem. Article 14 recognizes abortion as a woman's right, as I said, which is the first human rights treaty that actually does this. And as a result, states that have ratified the Maputo Protocol are obligated to decriminalize abortion. And so at the regional level, there has been efforts in terms of having a decriminalization campaign that was led by the Special Rapporteur on the Rights of Women in Africa, as well as other mechanisms at the regional level. So Article 14 permits abortion on the grounds of risk to the health or life of the pregnant woman, risk to the life of the fetus, incest, or rape. However, it shuts fall of permitting abortion on the grounds of request, which, as we know, the Choice and Termination of Pregnancy Act is quite progressive in relation to that. I think also Article 14 is interesting in the sense that it also frames abortion. Also, Article 14 is framed around gender equality. And also noting that in the drafting of Article 14, recently I was doing a chapter where I was looking at the travel repertoire, and some of the information in relation to that is that the Article 14 and the Maputo Protocol in general draws quite a lot heavily from the UN system as well as the European human rights system. So for instance, draws a lot from CEDAW as well as soft laws, as well as other international agreements like the ICPD, the Beijing Platform for Action as well. And in relation to that as well, the African Commission on Human and People's Rights have gone on further to adopt General Comment number 2, which is an interpretative guidance on the protocol's abortion provisions. As I said, about 42 countries have ratified the Maputo Protocol, which is really great, despite the fact that we do have certain countries placing reservation on Article 14. However, what we've seen at the African regional level is that there is evidence to show that African countries are making gains in terms of improving legislation as well as policies, and these are due to sustained advocacy, especially by the SRR movement towards the liberalization of abortion law. So grounds are consistently being expanded in relation to rape, incest, as well as danger to fetal health or of life as well. We've also seen regionally as well that quite a number of African countries, for instance, are incrementally recognizing access to safe abortion as a fundamental right. As I mentioned, just 2 months before the Dobbs judgment was delivered, there was a case or decision from Kenya, the PAC and AG case, in which really it was highlighting the commitment, for instance, of the Kenyan state to decriminalization of abortion. And we know that with the Kenyan constitution as well, that this was really progressive decision rather in relation to recognizing the right to abortion and women's right to terminate pregnancies. I think so. That's just the general overview with regard to the African regional system. I think there has been a lot of conversations, and I have been part of that. I think, in a sense, as you said, in relation to occupying both spaces, in a sense, as you highlighted when you were introducing me, I am in a US institution, but I also do and focus quite a lot of my work on the African human rights system and work through the Center for Human Rights. And so in a way, I have been privileged to see into both worlds. I have been in conversations with US counterparts in terms of how they're working on counteracting the backfall of what is going to happen due to the Dobbs case and the rolling back of Roe. But I've also been with my sisters and counterparts in the African region as well in relation to the implications of the Dobbs case and the rolling back of Roe on what is happening in the continent. I think, in a sense, there is quite a bit of genuine concern in relation to what will be the likely implication of that. I think, as Cathi highlighted in the South African case, it's definitely more of a political threat than a legal threat, given the strong framework that South Africa has through the Constitution, but also through the Choice on Termination of Pregnancy Act. This is not really true for quite a lot of other countries as well, especially in terms of the legal framework, despite the progressive steps that we're making towards reforming abortion laws in the continent. And I think partly as well is that the political trade in quite a lot of the African countries is that we've also seen, as Cathi said, especially the increased movement of the anti-choice, the increased activities of the anti-choice movement in quite a lot of the African countries. So recently, I was part of a team of researchers doing a mapping of the anti-choice movement activities in South Africa, Kenya, and Ghana. We were trying to understand, for instance, how the transnational nature of lobbying, as well as how discourses are drawn upon. And I think a good example, and Cathi is quite okay with this and can speak more to this case, which is the fetal burial remains case in South Africa. However, it was interesting in a sense, especially when we were doing the mapping, how the arguments that were used in the fetal burial case was very similar to arguments that were made in the 2019 Box and Planned Parenthood case in the US. In this case, the US Supreme Court upheld the constitutionality of the Indiana abortion law that mandates any clinician or facility providing abortion services to bury or cremate fetal remains rather than disposing them as medical waste. And as I said, Cathi can speak more to this. She was also supporting in terms of some of the other arguments from the side of the sexual and reproductive rights movement. And so in a way, my assertion is that whilst the likely implication of the Dobbs decision will likely not be a legal threat in quite a lot of the African countries, despite our very rudimentary abortion laws, but it's also a political threat because, as we said, because of the increased movement. And one of the other things that have also been highlighted in conversations that I have been as well is with regard to the global gag rule. We know that due to US power and influence, obviously, that what is currently happening in the US will likely result in threats to the right to abortion for the rest of the world, including Africa. So for the global gag rule, we saw that when Trump came into power, that it was reinstated in terms of non-US organizations that receive US funding couldn't provide, refer to, or promote abortion. President Biden, when he came into office in 2021, rescinded this. So there is the possibility that when a Republican government comes into power again, this might be so. But I also want to acknowledge that whilst this might be a threat in a way in relation to the reinstatement of the global gag rule, the progressive developments that we've also seen in the African continent was also during the global gag rule period. So despite despite the implications of the global gag rule and the consequences for quite a lot of the movements in the continent and the work that we do, progress was really made despite this particular situation as well. And just lastly, I would since the Joshua is not here, I think in relation to one of the other issues around the applicability of the US judgment, I think in relation to wider applicability for the rest of the countries and especially African countries as well. I think for me, my personal reaction to the Dobbs judgment, it is interesting. I mean, it's the US, it has influence, so everybody looks to the US in terms of what they do. I think in relation to the Dobbs judgment, reading the judgment itself, but also reading the dissent that was also written as well, the judgment itself, I think, is not persuasive judicial reasoning, and that's my own perception. I think, as Cathi rightly said, I think the Dobbs judgment is a clear indication of the success of the Trump administration. I think really that's really what it is about, that Trump was or has been successful in appointing conservative judges. And abortion, as we know within the US context, is a tool in a political and religious battleground anyway. So is there any sort of jurisprudential lessons that we can learn or we can draw from the African region? I think partly is just going back to, I know I'm mentioning Cathi a lot, but thank you, Cathi, again, for setting the stage with regard to Roe inspiring abortion reform beyond the US, but also in terms of how it utilizes the constitutional right to privacy that overall state criminalization of abortion. We know that, as Cathi said, that it drew from the due process clause of the 14th Amendment of the US Constitution, which has been interpreted as to protect an individual's right to travel. I think in any event, African regional jurisprudence is different, especially with regard to the Maputo Protocol and Article 14, which, as I said, is framed around gender equality, whilst the US jurisprudence, especially Roe, I think, from a historical perspective, has been developed around the right to abortion as a right to privacy, which is not sort of the interpretative roadmap that we take at the regional level. Anyway, so I'll stop there. I think in a general sense, as I said, I think from the various conversations that I've been in, is that quite a lot of people both in and outside of the US are shocked by the Dobbs case, by the rollback on Roe v. Wade. And obviously at the US context, there is a lot of attention being placed now on on actions that needs to be taken, especially battlegrounds at the state level. But I think from the African regional level, I think definitely the US can learn a lot, especially with regard to the social movement, regard to the feminist movement, and sort of the strategies, including the strategies that Cathi and others in South Africa, for instance, took in relation to going the route of the Choice on Termination of Pregnancy Act, as well as what is happening in various African countries, from Mozambique to Ethiopia, as well as other countries that are consistently expanding the grounds on accessing abortion. Thank you.
Great, thank you so much, Dr. Nabaneh, for that presentation. I think we can jump right into the questions. As Prof. Bilchis has said, you're welcome to post questions in the chat box or raise your hand if you want to bring forth a verbal question. So currently in the chat, we've got two questions, both from Prof. Bilchis, and I'm just going to read them out for our panelists. The first, I think, was for Prof. Albertyn, and it says, the reasoning in Dobbs is very much linked to the US's history and tradition. Of course, the reasoning of the SC in the USA is suspect on its own terms, ignoring, for instance, a submission by historians. Nevertheless, is that particularly a way to limit its effect worldwide by arguing that it is limited to a very narrow view of US history? And then the question for Dr. Satang is, the text of Article 14, subsection 1 does not seem to recognize directly a right to abortion, though some rights could be seen to imply that, though also interpreted narrowly not to. Article 14, subsection 2, paragraph C, seems to limit abortion to violence in health and seems to be a state duty rather than a right. Please, could you elaborate on how the conclusions have been reached that this is a fundamental right? I'll hand over to Prof. Albertyn first, and then I think Dr. Satang, you can also respond.
Thank you. Oh, sorry. Okay, yes. So I mean, David and everyone, I do actually think that generally the Dobbs judgment is very much American. I don't think it's particularly comparable to most other constitutional jurisdictions. We have different constitutions, we have different jurisprudential histories, we have different modes of interpretation. So not just on what you're suggesting, that you can limit its effect worldwide by saying it's a very narrow view of US history. I mean, I think there are many ways in which you can limit its effect worldwide. Yes, it is a very narrow view of US history, and I know Reva Siegel has written something in the New York Times and on a blog post where I think she's written about how actually there was a lot of other history, alternative history around families and women and decision-making that the judges failed to see in 1868 and thereafter. I mean, the doctrine of original intent and the idea that it has to be rooted in a nation's history and tradition to the extent that it must be what was there for them 200 years ago. For us, I mean, we wouldn't even look at what was there 25 years ago, let alone 200 years ago. So I really think it's almost idiosyncratic to the states. But that doesn't mean we also don't have to worry and be careful around strategy, because the strategy there was to get the right judges in, right? Judges that would actually write a bad judgment. And I agree with Satang, it's incredibly badly reasoned. And in the end, it's a moral choice. Judges don't like the fact that you can terminate pregnancies, and they try and wrap it in all kinds of jurisprudential and legal arguments. When push comes to shove, actually, they don't believe that women should be able to do that. And that's what that judgment is all about. And if you get the right judges in, then they do. And I think we have to worry in the States about what else they do. Now, it's only Clarence Thomas, I think, that actually says we have to worry about, I mean, I think he'd even relook at Brown versus Board of Education. But it's only, the others all say it's not the same. And they say it's not the same because abortion is around the protection of fetal life. And that's how they distinguish it. And that's in a way also how you can see how there's a kind of moral idea operating in this judgment, a moral choice operate. I mean, I'm not saying morals don't have places in judgments, they do. And I think most of us are kind of saying partly there, but for the grace of God, but we're also saying, actually, no, we're different, and it's not going to happen here. But as I said, never say never. So we have to be wary of who our judges are. We have to be wary of how we argue these cases. We have to be wary of what the opposition is saying, whether it's about abortion or same-sex marriage or anything else that actually vests in the right to privacy, dignity, autonomy, those notions that there is a sphere of our lives in which the state can't tell us what to do. Yeah, that's my comment on that.
Great. Dr. Nabaneh, over to you.
Sure, and I'll be brief. Thank you, David. So as I said, with Article 14, and you're right, David, it recognizes, and I did mention before, abortion under certain conditions, as you rightly said. I think partly it is very much framed around protecting women, the pregnant woman, but also in terms of the fetal health, as very similar to what we have with the national laws as well. As I said, part of what we have in the continent is colonially inherited abortion laws, which are very much replicating, especially for common law countries, replicating the Bourne case or the Bourne judgment from the UK, and which is very similar in terms of protecting or allowing abortion on certain grounds. And so what the Maputo Protocol did in a way, whilst it is very progressive, as I said, as the first human rights instrument that provides for abortion under certain conditions, it was also not that very innovative. Like, it did not go outside of the box to actually just say that there is a specific right to abortion, or even, as I said, given the limited grounds that abortion on request is not provided for in the Maputo Protocol, which is very much different from what we have with the Choice on Termination of Pregnancy Act in South Africa, which is quite progressive as well. I think when you look at the discussions and the travel preparatoires and the conversations around the drafting of the Maputo Protocol and eventually Maputo Protocol coming into force, I mean, we can agree that it is a compromise document that to get African countries and African states to agree to sign a human rights instrument that talks about abortion was quite a bit of a stretch. Anyway, so I think in a sense, whilst quite a lot of reproductive rights scholars as well as activists will have just wanted specifically a right to abortion, just that this is what we have with the Maputo Protocol. But I also need to state that as well. I did briefly mention the general comment number 2. And so the commission has in a way as well been quite progressive in terms of what does the Article 14 and the implication of Article 14, especially for state obligation, look like in general comment number 2, as well as the campaign on decriminalization of abortion. And so whilst the Maputo Protocol is quite limited in that sense, that the commission, as well as what is coming from the African Commission, has been progressively expounding on that. But I think in a way as well, I think what we have with the Maputo Protocol, why is this not the best or the ideal for us as well? I think in a way as well, we acknowledge, as I said, that it's a first human rights instrument that recognizes abortion in those despite the limited conditions. And so as a way, it also serves as a tool, as an advocacy tool, both for activists, but also for folks doing work on the ground in terms of both law reform, as well as policy, and going back to an earlier point that Cathi made, especially around implementation. As I said, about 42 African countries have ratified the Maputo Protocol. What we've seen though is that whilst there is progress being made in quite a lot of the countries as well, that some of the national provisions are not in line or aligned with the Maputo Protocol. So obviously a good example is the Gambia. Abortion is criminalized in our penal code and only provides for very restricted conditions. So just on the regard to the risk to the fetal health and the life of the pregnant woman. So it doesn't expand on the other grounds that the Maputo Protocol provides for, despite the fact that the Maputo Protocol has been domesticated in our national laws through the Women's Act of 2010. So that's one, but also even in countries that have progressive abortion reform, what we've seen is implementation is quite a challenge. Implementation of the laws, and South Africa is a great example of whilst having very progressive laws, but then in terms of access to abortion, especially with regard to not emerging issues, but issues, emerging trends, such as consensus objection, as well as the work that the anti-choice movement is doing, given that we've also seen that the anti-choice movement now has satellite offices in South Africa, in Kenya, in Ghana, as well as in other countries. But I think whilst we're talking about abortion, I also wanted to flag that what the anti-choice movement is also doing is not just a focus on abortion, but a focus on the bundles of sexual and reproductive rights. So we are talking about LGBTIQ+ issues. We're also talking about the biggest issue that they've really been taking up, which is comprehensive sexuality education in a lot of the African countries. So I think for a lot of us that are working on the ground, reproductive rights advocates, as well as others that are working on the ground, I think also need to think around strategies in relation to how to bring together the reproductive rights movement in various countries, as well as the regional level. I know that we do quite a lot of work in siloed ways, but the anti-choice movement is very strategic in the way that they are doing things. So perhaps one of the things that we can do is start rethinking of what are some of the strategies, especially in given the intersectionality of the issues, and in terms of bringing the different groups of people together in relation to the work that we do. But I think also acknowledging that activists, whether lawyers, as well as other advocates and others that work in the movement as well, have been spending a lot of time just reacting to what the anti-choice movement is doing. So taking time to go to court, taking time to, rather than the work that we want to do, the work that is needed to be done. So I think in a way as well, it's also draining on the reproductive rights movement. So that's also one thing to flag, especially as I think with what is happening with the Dobbs judgment and rule, that that we will see increased activity with regard to the anti-choice movement, especially with regard to countries that are making progressive stands, such as Kenya, Ghana, as well as other countries as well. Thanks.
Sorry. Prof. Bilchus, did you have a follow-up question?
Yes, I just wanted to thank you very much to Dr. Nabaneh for that response. And I just wanted to raise that because I just wanted to ask, I suppose, that more informationally, whether or not there are many countries in Africa who have a law which is less, which provides less than the protocol. So in other words, when I read the protocol, although it has a progressive reading, it also has a relatively conservative reading, in the sense that, to me, it's not that, you know, actually morally, anyone who denies a woman an abortion on grounds that her physical health at least is endangered, that really is an extremist position to take. So I wanted to ask, what are the laws in many African countries? Are there actually countries which prohibit abortion full stop with no exceptions? Or does the African protocol actually in some ways just cement the consensus of laws that currently exist? Or does it actually press state parties to legislate further?
Do you want me to go over? Yeah?
Yeah, sure.
Okay. Okay. Now, David, I didn't have my morning coffee yet, so I'm just trying to think of just doing a quick mapping in my head of the 55 African. We have 55 African countries, right? Yeah. Anyway, not to say that I don't think I'm wrong, but to say that I do not think there is any African country that totally criminalizes abortion on all grounds. So what we have at the continental level is different levels to the grounds that they provide abortion on. As I said, you know, you have countries like the Gambia that provide that allows for abortion based on 1 or 2 grounds, and mostly the physical health as well as the life and the fetal right risk to those grounds are actually provided. Then, due to, as I said, due to the impact of the Maputo Protocol, for instance, as well, that we've also seen in countries like Ethiopia, as well as in other countries, that the grounds now are eventually being expanded. So so I think in a way, this conversation also goes back to currently what the reproductive rights movement has been dealing with. So there is, and globally as well, not just at the continental level, that there is a movement to say we just need to decriminalize abortion full stop, right? Whilst others are like, yeah, that's great, but within our own national or local context, it will be very difficult to actually be able to achieve total decriminalization. Total decriminalization means no laws, getting it out, or like treating it as another health services that doesn't really need the state getting involved in, right? Whilst other folks from other, depending on their context, are like, based on what we've seen, we can also use as I said, use the Maputo Protocol as an advocacy tool to say that state A, B, and C have ratified the Maputo Protocol. They are obligated, especially, as I said, with General Comment number 2, it really goes on to expand on what are the legislative measures, as well as the other measures that states should take, especially in terms of not just having law reform, having law reform, but also ensuring that the services are available and accessible and adaptable, and all of those things in relation to, which is related to the right to health and accessing health services as well. So in those cases as well, that the activists have used the Maputo Protocol as a tool to say, why don't we expand abortion based on the grounds that are being provided for in the Maputo Protocol. And then you also had to have the progressive countries that have more progressive provisions, like South Africa, than the Maputo Protocol in that instance. So I think in a way the African continent, especially with our abortion laws, is a potpourri of laws with different levels and variations in terms of what they provide for in relation to that. But I think one of the other did I lose my thought? No. So one of the other things as well, I think interesting for African governments as well, and even with the Maputo Protocol, I think what we've been grappling is the lack of litigation around the abortion provision. Well, litigation around the Maputo Protocol itself, that's one, but more specifically around abortion, because I think partly as well, we do need jurisprudential resources and materials emanating from the African Commission or even the African Court that can guide state, but that activists and reproductive rights advocates can also use to hold government accountable as well. But we've been grappling with that, especially around litigation in relation to the Maputo Protocol, but also in terms of implementation of the protocol itself. So thank you, David. I think those are very valid questions in relation to what we have at the continental level, but also acknowledging that with our colonially inherited penal codes, that this is very much replicates what we have with the United Kingdom with regard to the common law, even though we know that the UK has progressed in relation to that, but very similar to what we have with laws on homosexuality that are also colonially inherited and still is in our penal codes, despite the former colonizers having changed their laws and so forth. So we've been seeing that as well. And perhaps, I don't know, I mean, I suppose I should throw in the word decolonizing, and perhaps that might be a strategy for us to use in relation to pushing for more abortion reform in the continent, as well as, yeah, anyway, thanks.
Thank you so much. We've got one more question in the chat group. If there are any further questions, please feel free to put them in the chat as well. We've got a few more minutes. And this one is from Joshua Davis, a researcher at SciFac, for both Cathi and Satang. And it says, is the lesson of Dobbs not that progressive lawyers should have less faith in judicial review in general and should perhaps expend more energy on influencing the political process? Cathi, if you want to answer that one.
Yes. So yes, without question. That's what I tell my students every year. Don't be litigators, go and join government and make it work. Without question, we really need to be getting the correct laws and policies in place through the political process. It's something that the early 1990s were perfect conditions to do that, but less so now. But yes, first prize is democratic politics and the political process, without question. I just want to make a comment on the African protocol, which is, I think, it certainly was at its time, and I think it still is the most progressive international document on reproductive rights, but it's a very moderate document. It's a moderately progressive document. It doesn't actually recognize women's free, unfettered choice. It's a conditional choice, right? You either had no choice in falling pregnant because you were subject to gender-based violence, or you have no choice in keeping the baby because there are problems around the health of you and your baby. So women are handed these morally acceptable reasons to have a termination of pregnancy. It's not a document that says we respect women to exercise unfettered moral choice at any stage of their pregnancy. So that's my criticism of it. Not that I'm saying it should be anything else. I think it's a critically important document, and I agree with Satang. In Africa, it's a critically important document because you want to get legislation in place, and it's probably very difficult to get from limited abortion to a more unfettered situation of choice. But it's a moderate document.
Yeah, and actually, on that note of unfettered choice, I have a question regarding, the recent Kenyan judgment, which was Park versus AG, because what was actually being challenged in that case was the lack of a provision that actually allows women to choose abortion generally out of choice, not because of certain conditions. And what the court basically did is find that the existing provision was unconstitutional because it would compromise the right to life in forcing maybe women to go for unsafe abortion services, the right to privacy, the right to bodily autonomy. And I'm wondering how the court in Dobbs dealt with such issues, because I've only had a chance to browse briefly, but maybe either of you could maybe let me know or clarify how the court in Dobbs dealt with issues such as the right to life and the right to privacy for women in taking away or overturning Roe versus Wade.
So they overturned Roe versus Wade was based on the right to privacy, right? And then that that saw an evolution through the other abortion cases, through Cathi, but also through the cases on same-sex intimate conduct and same-sex marriage. It evolved more into an autonomy right, so beyond privacy. And of course, privacy was criticized in Roe versus Wade because it was narrow. And in fact, its grounding in the right to privacy also prevented an obligation on states to provide funding for abortion. And there was actually a Supreme Court case on that. So there was, feminists criticized the grounding of Roe versus Wade in privacy. And that jurisprudence did evolve through the cases. But in Dobbs, I mean, Dobbs just basically said it's not there in the due process clause. I mean, basically Dobbs says, you know, this is all wrong. It's never there explicitly, nor is it there implicitly based on their particular historic original intent reading of 1868, I think, when it was there. There's no such right. I mean, I basically think the way I read it is they're saying there is no such right. There's no constitutional right to abortion in the American Constitution for women. What has to happen is that needs to get thrown to the states, the states in America, and they can decide for themselves. So actually, it is a point of the political process. But they also don't recognize that rights are there to protect vulnerable groups as well, which I think is another problem, and which is brought out by the minority. But Satang might want to add to that.
Thanks, Ropa. No, Cathi, you adequately addressed that. I just wanted to just go back quickly on the question earlier raised by Joshua, and I think Cathi answered it as well. Just to add, I mean, I am on the side of Cathi, but I also think perhaps, do we have to choose? Well, yeah. I mean, we have limited resources anyway, so we also have to prioritize what we do. But I also wanted to just, in relation to that, I just wanted to spotlight how, for instance, the anti-choice movement is sort of influencing the political process. We know that in the South African case, for instance, there has been several attempts by the ACDP as well as others in terms of bringing in a private member bill as well as others. But what we've also seen is that you have nothing-based, and I mean the US or UK as well as other countries, organizations based in these areas that sort of are using international and regional spaces to influence our politicians. So, for instance, we've seen that at the UN level, where we have, there is this anti-choice person, Sharon Slatter, who is very known in the anti-choice movement. She has a small organization, but does quite a lot of work in relation to influencing, our politicians that go to the UN, has and continues to conduct and hold meetings for them in terms of influencing them. But we've also seen that in Ethiopia, in Addis as well, with the African Union, where they usually also target our politicians as well. And they've also opened satellite offices, even in Ethiopia, in Addis, having headquarters there, in terms of it being a targeted space as well. And I think perhaps the biggest thing that we don't really talk about is the fact that the anti-choice movement is really pumping a lot of money into the work that is being done in the continent. I mean, a good example is, for instance, with the pregnancy crisis centers that Cathi mentioned, but others in relation to these organizations in South Africa, for instance, receiving 100,000 employees. Like, I think in a way we have an inkling of how much money is being pumped, but we do not have a clear picture of mapping, where the money comes from and where it's going. But there is money coming in into the work that has been done at the regional level. So I think in a way that, we do need, I suppose, because of the strategies that the anti-choice movement takes up, we do need lawyers that will go to court. But I think in a way as well, I think even when you compare what is happening with the US with regards to the African regional developments, as well as with the amazing development that is happening in the Latin American countries, there are different strategies that work in different spaces. And I think perhaps in terms of drawing lessons, in terms of drawing best examples from other contexts and other countries, is really looking at what the local context is and what will work in that instance. And as I was mentioning before, in terms of, you know, going for a full-blown decriminalization versus advocating for expanded grounds, or going through legislative processes and having a law like the South African case, or having a court-centered strategy like the US case. I think all of them come with their, you know, their pros and cons. So I think in a way as well, is really for countries to see what might work best in their situation, but also learning lessons. I mean, South Africa is a good case study in terms of consensus objection, and how, for instance, maybe the lacuna in the Choice on Termination of Pregnancy Act might have solved that problem, even though we know that in the Latin American countries that have provisions and legal regulation around consensus objection, despite that it still happens, and that it prevents women from accessing legal and safe abortion. So there are upsides and downsides to, I suppose, all sorts of, whether it costs court-centered strategy or legislative strategy, or, you know, advocacy from the bottom up as well. So I think in a way as well, just learning lessons from others. But we do, you know, in a sense, I think perhaps the way, you know, lawyers were always more into, you know, going into the courts and having jurisprudential materials and resources that we can use to push for, you know, the implementation of the specific right. However, perhaps in terms of rethinking strategies as well, we need to get into the political processes to be able to influence laws that come out, as well as ensuring that we're also in spaces where implementation of these laws also take place as well. But anyway, I think David has additional comments and other sorts of arguments around that.
Yeah, I'm just going to read out Prof. Belcher's follow-up question to Joshua's point, which says, but isn't the point about lawyering more complex? The political process can easily lead to regression with influence of conservative politics and money, particularly now with growth in Africa of US groups trying to have influence. So isn't it more secure to have it recognized constitutionally through courts? I think Prof. Albertyn had started to respond.
It's not, we don't live in an ideal world. So what you can do depends on who you are and what you've got. I mean, ideally you need both. Ideally you need the constitutional protection and you need the law in place. And even then it's only a starting point, because we know that actually then getting many laws implemented is a whole new set of struggles. But whether you can get the constitutional protection and whether you can get the law in place is going to depend on your kind of political and economic context in many different ways. So you might not have a choice to get, you know, in America, I don't think it was possible to get a federal law in place. I think it might still not be possible to get a federal law in place, which is an ideal solution maybe to abortion in America. It's only been done at state level, and therefore a lot of the fights have happened through litigation at state level. Because the political process at federal level has not been able to get something that was more consistent and more protective. So it swings and roundabouts. I mean, America's showing us that, you know, you go through these different stages. America, I think, is stuck in the stage now for how long are these judges going to be there? I don't know, is it 20 years? So, yep. Things change, and so now in America the only thing they've got is the political process, because the courts are not there for them.
Yeah, and I think Joshua also adds that the Dobbs judgment shows that judicial decisions are perhaps just as vulnerable to conservative influence and just as insecure as legislative choices, and they also have the vice of lacking democratic legitimacy. So,
yeah, I might quibble with the democratic legitimacy point, but other than that, precisely, these things shift and move.
Yeah, absolutely. I don't think we have any further questions, so I think, oh, Prof. Belcher wants to say something. Okay.
Yes, I mean, I want other people to come in. So if other people, please come in. But I actually wanted to pick up on the intersectionality point that Dr. Nabaneh made about these issues and that were raised, obviously is brought up in a negative way by Justice Thomas's judgment. And I've got a question about it. I think it's a strategic question in a way, but is it useful to emphasize the intersectionality of issues like abortion and same-sex marriage, given that the approach of someone like Thomas would be, well, we should reject all of them together, or is it now better to, in a sense, assert the separation of these issues, that we should try and separate out these issues so we don't have backtracking and try and emphasize their differences. Certainly in the US, I imagine you would want to distinguish the Albertyn judgment from the Dobbs judgment, for example. And there seems to be, it's an interesting thing, right? The conservative, I think Alito wrote the progressive judgment, recognizing, I forgot its name, that sexual orientation kind of is included in sex and gender discrimination. So what are your thoughts about that question? I mean, it's, I suppose, a strategic and a moral question, I suppose, in some sense.
Cathi, do you want to go first, or do you want me to attempt to go first? Okay. Okay. So yeah. So I think in terms of that question, which is loaded, and I'm going to attempt to answer it. I don't think I have the answer. As I said, I think it is one of the key questions for the reproductive rights movement in general, to have a conversation about what might be the best strategies going forward. And I think part of our conversation, or what is coming out of this conversation, is that the US context is very different from what we have, in Africa, as well as in various other spaces, despite the fact that the influence, because of their influence and power, ultimately there might be implications for the rest of the world in relation to what is happening there right now. But as I said, I think what the anti-choice movement is getting down, though, is that they are looking at the whole bundle of reproductive rights, right, as a whole, whilst you have organizations that will work on CSC, or those that work on abortion, and those that work on LGBTIQ+ or sexual minority rights issues. In most cases, they also look at it as the judgment highlighted, look at it as a whole component, as a whole bundle of rights to just deal with and just scrap, because it's not useful. It's not something that should be given consideration in that sense. And I think the way that we work, both in our countries as well as in the regional level, I think is sort of a downside in terms of, as I said, we do work in silos. So you have folks that work on sexual minority rights, in one group, folks that work on abortion rights in one group, and those that work on CSC, or decriminalizing sex work. So even within the reproductive rights movement, you have all these pockets and folks. I mean, I'm not saying that everybody needs to come in a merry-go-round and agree and all of that stuff and do the whole kumbaya thing. But we also know that even within the reproductive rights movement, that there are folks that are not into the push for decriminalizing sex work. So, but that's a whole nother conversation I'm not trying to bring up anyway. But all I'm saying is that the anti-choice movement is strategic in a way that they, despite the topical issues that they are dealing with, are coming together and actually attacking the whole bundles of rights instead of just the right to abortion. And so I think in a very strategic way as well, I think reproductive rights movement, the different groups need to come together to strategize, because in a way as well is leveraging resources. Because what we've also seen with the anti-choice movement is that they've been using so-called experts. In Western Cape, not too long ago, you had a so-called expert who was talking about transgender and and all of those. And these folks are actually provided space. They come into parliamentary hearings. They go into big spaces and are actually share misinformation, obviously misinformation, even with the pregnancy crisis centers, sharing misinformation, which is taken as information and which is taken as good knowledge. So what really, I think from a strategic perspective, despite whatever strategy, whether it's court-centered, whether it's legislative, as well as other strategies that are being taken up as well, is in terms of bringing the movement together in a way that they can leverage on each other, that the movement can utilize, whether it's a lawyer that focuses on the right to abortion, for instance, can support in terms of developing arguments for a case that has to do with transgender rights or CSE and things like that. So I think for me, from my own perspective, I really think the movement coming together makes sense in terms of it being more strategic than the continued way we're doing working in silos, which as I said, as we continuously react to what the anti-choice movement is doing, we're sort of dispelling the small resources, the small time that we already should be allocating or prioritizing to other areas as well. But perhaps Cathi has more from her own perspective. Thanks.
Sorry, Cathi, you're muted.
I agree. I think if you look back at 25 years of litigation in South Africa, you can see a lot of missed opportunities, some conscious and some less conscious, where groups have separated. So if you think about the bifurcation around same-sex and heterosexual cohabiting couples, could that not have happened had we more carefully thought through the jurisprudential basis for rights for same-sex cohabiting couples? And not, I'm not sure that was the litigating party's fault or the judge's fault, but you look at the Treatment Action Campaign case and the failure to deal with women's choice. And that was quite a hostile, actually, sort of set of incidents. So you look back in South Africa, and there are moments where the jurisprudence, moments where, and of course history is a perfect science, and I'm not sure it would have been different, but there were opportunities there that were not taken. So I think that where there are opportunities, they should be taken as much as possible. But I think sometimes you're going to find yourself in places where your interests just differ. And I've been there. And you kind of have to accept that and go around that and move on.
Great. Any follow-up questions? Prof. Bilschitz? Good. Great. I see there are also no other questions in the chat box. So I think with that, we can wrap up. Thank you so much to our panelists, for everyone who attended, for the questions. We're truly grateful. Just going to hand over to Prof. Bilschitz to also offer some concluding remarks.
Yes, no, I just want to also express gratitude to Professor Albertyn and Dr. Nabaneh for a fantastic exploration of these issues and discussion. And yes, we hope that we won't see more backtracking as occurred in the US, and hopefully more progressive developments of women's rights in Africa, and to try and limit the effects, I think, is quite important, of Dobbs, because the US still has a kind of purchase on the imagination, unfortunately, judicially worldwide, and what is coming out of the US is disturbing. So I think it's important for us to kind of think about how we, in our respective jurisdictions and across our different circumstances, address these issues. So thank you for that really fantastic discussion, and we look forward to next week. We're talking about intersections, so next week exploring a relatively unexamined intersection between, although there have been some important work between issues of gender equality and oppression of non-human animals. And we're also going to have a discussion of the Bwania case later in the month, which overturned Fawkes versus Robinson. So what was just alluded to by Cathi, and unmarried heterosexual partnerships and rights therein. So looking forward to all your participation in the next seminar. So thank you very much for all those who joined, to our panelists, and also to those joining online, and all the best. Cheers.
Thank you.
Bye.
Bye.